Let me bring in Marina Jenkins here. And as I introduced you, Marina, you're on the side of the plaintiffs in this case, and you're working on a lot of other potential challenges. So first, let me get your reaction to this decision. You heard Laura's analysis. You heard my conspiratorial cynicism there. I'm not saying that's what I believe, but that's certainly in the ether. What do you think of this decision, and do you feel as if it's a solid opinion in your favor, not just an outcome in your favor?
Absolutely. Laura's absolutely right. This case should have been a very easy case for the court to decide. Should have been 9-0, based on existing precedent. The law under Section 2 of the Voting Rights Act has been solid, has not changed significantly with respect to redistricting for decades. And so this was another instance where we were wondering whether the court would stick to precedent or whether they would do something different because they wanted the law to be different than it is. And so, I understand the curiosity around the motivations behind sticking to the law as it exists. But when we brought this case in 2021 and an iteration of it in 2018, it was very clear that this is a straightforward win under existing law of Section 2. And the 3-judge panel with 2 Trump appointees agreed with us, and now the Supreme Court has agreed as well.
Now, Marina, though, you said you were you were shook by this decision. So you seem, of course, they did it exactly the way we expected. It doesn't sound like you did expect this.
It's been an emotional day, I have to admit. I think the emotion comes from the confluence of understanding where the law is and what it should be, and that we should get a straightforward result, but having real doubts about the fealty of this court to the rule of law. And I think based on last summer's outcome in Dobbs, it's a fair place emotionally to be to really wonder whether they're just, everything's game and it's all up in the air at this point.
So based on this opinion, where do you believe you have the ability to force some remaps in some of these, we know about Louisiana, Georgia's out there. Is Florida, is South Carolina, or any other southern states?
So the 3 states, in addition to Alabama, that have active Section 2 litigation are Louisiana, Georgia, and Texas. So those are states where there already are cases moving. I think Alabama, Louisiana, and Georgia are almost certain to get results in favor of voters, but in time for the 2024 election. Texas Texas always is more complicated. There are a lot of different things happening there. Florida, there's no active Section 2 case. We have a state-based case under the Fair Districts Amendments in Florida. There is a racial gerrymandering case in federal court in Florida. So there are some other ruminations, some other things happening in Florida. So a Section 2 challenge that would be new would take a little more time to develop.
Right, and you're right. There's a whole potential on the whole whether that constitutional amendment of fair districts in Florida, whether it's constitutional in the state constitution.
Thanks for watching our YouTube channel. Follow today's top stories and breaking news by downloading the NBC News app.